equipment. Disgraced former Congressman Anthony Weiner, who is serving a 21-month prison sentence for sexting with a 15-year-old girl, will be released early for good behavior. Weiner, a once prominent New York Democratic congressman who resigned in 2011 following the release of sexually explicit text messages he exchanged with women other than his wife, is serving his sentence at the Federal Medical Center Devens in Massachusetts. Weiner is now scheduled for release on May 14, 2019. Those were today's top crime stories. I'm Anthony Velez for Law & Crime.
Okay, listen, let me just bring on real quick my Jersey girl. I know a lot of you guys in that chat room have been saying, when is Linda Kenney Baden going to be back on with Bob? Well, here she is in the flesh.
I'm going to try to chat in that chat room. I can't do what you do. You do everything. You chat, you host, you talk.
Yeah, well, you know what, Linda? I am going to show you how to do it because these chatters are unbelievable. They're like the jury, the third eye of the Law & Crime Network.
I love it.
Yeah. So how about this Weiner thing? I mean, look. Is this guy just? I just
laugh when you say this Weiner thing.
I know. We can go through all those. But I mean, you know, this guy. What is it, Linda? When we encounter people like this, they're prolific careers. They're doing great, respectable in the community. They're leading people, and it's almost like suicide with what they're doing.
They think they're untouchable. It's what it comes down to. They think they're untouchable, and no one's going to bother them because they're important. I guess it's certainly a self-importance of some sort because this was sick. I mean, he had a wife. He has a child. Can you imagine the child? I mean, if you don't have any respect for yourself, have respect for your kid.
Yeah, well, I think actually, if I recall this story, one of the problems that he got into was that he actually had taken one of these surly, crazy photographs with the child in the bed, if I believe.
Yes, you're absolutely right.
I mean, like, again, and that's a danger to the kid.
That's right.
And, you know, here he goes, and he sets this cascading set of things in motion. Do you know anything about the wife?
All I know is that she is a political operative for Hillary Clinton. She's been her aide, and doesn't matter who she is, she doesn't deserve to have her child put in this position because she made the wrong judgment of marrying the wrong person, which a lot of women do, and sometimes men also.
Yeah, well, you know, listen, they're also saying that he's getting out early on good behavior. Can you talk to our audience a little bit about how that works and why it's actually an important part of the keeping peace in the facility with respect to a violent?
If you put somebody in a prison for a long period of time and you have no ability for them to get out, they'll do anything. It doesn't matter how many things they have on their record, how many abuses, how many violations. They could be even a danger to prison guards, right? But if you give them an incentive to get out early, so they get a week off for every 51 weeks of good behavior with nothing on the record, then there's an incentive for them to have good behavior, and it tends to keep the peace in the prisons. I know for a long time there were a number of prison corrections officers who were for that and were against taking away this ability because it could endanger them.
Yeah, that's been my experience as well. Last question for you. Going back to that arrogance piece that you talk about, or whatever that little thing that switches in the minds of these kind of guys, what's your prediction that in a little while when he gets out, he is going to be back in the public arena again?
He's going to be back in the public arena, and he also may be back into jail again because, you know, any little violation could put him right back into the clink.
Well, that's true, too. And with crimes like this,
sex crimes,
if they're not treated, the likelihood of that, even with treatment, it's a lot of times unsuccessful.
That's right.
But it'd be interesting to see whether or not he got some sort of treatment in the jail, and when he gets out,
whether he's going to be banned from social media as a condition of him being out in some way.
Yeah, I would imagine that one of the conditions is going to be that he has no access to computers or
and then what will happen is he'll have a different name and go to a different computer, and if he's really unable to be corrected, it'll happen again.
Right. Well, listen, the great story, and so is this trial, the Colley trial. We covered it extensively on the Law & Crime Network. There are so many moving pieces to this. I love it, Linda Kenney Baden, because it's got a lot of defenses in it. Not that they are necessarily good defenses, but they're in there.
Right.
And we have a lot of opportunity to talk to our audience and the people in the chat room about things that during the trial we just didn't have the ability to do, but now with some hindsight we can, and give you some little nuances about how we prepare cases as prosecutors and defense lawyers in a matter like this. And there could be no better person to do that with than Linda. So let's go to the prosecutor's opening statement in Colley, and we'll talk to you on the other end. Okay, so this is the Colley case. That's the prosecutor's opening statement. Linda, we were talking about, and I just want the jury to the audience.
We have a jury. The audience.
They are our jury.
Right.
methodically pointing out all of the different victims in the case and the things that he had done, the motive for it, having been at that hearing earlier where he was very agitated. He called it, the father basically told the police he was very upset. He goes there. He's going for a specific target. He's looking for the boyfriend. He goes into the closet, passes one person, shoots and kills another one, then goes into the bathroom where the wife is, kills her, and then flees. Now, I think the prosecutor's emphasizing this in order to get around passion, provocation, or anything other than an intentional murder. Can you explain that to our audience?
Well, let's start with the fact that it occurred from the previous time when he went in and found the sex toys. So this man already has that in his mind, that she has a boyfriend and she's playing sex toys with. So when he goes to court in that morning and the judge is ruling against him and he thinks that he's never going to see his children again, he is really angry, right? That's not, and he thinks about it. He thinks about it. He has to talk to his father. There has to be these intervening events. He has to drive. He has to go, and then he has to go through the house. He has to be methodical. He has to pick out who to shoot, where to shoot, etc. So there's not only time, but there's a lot of intervening events. Versus passion, provocation. The classic we learned in law school was that a husband comes home, right? This is when wife were considered chattel, by the way. Husband comes home, worked hard all day, and then finds his wife in bed with his best friend. And he immediately takes out the gun that he has hidden in his drawer and shoots the best friend, because he just can't take it. It happens on the spur of the moment.
You bring out a really, it's funny, I was thinking exactly of that law school example before we came on set. So the elements of the offense are that the provocation was reasonable, that the jury would have to find the provocation was reasonable.
No doubt.
The provocation was such that the person did not have an opportunity to deliberate.
That's correct.
And could not cool off. And in fact, was provoked and in fact did not cool off. But you bring up an interesting point.
Right.
Is it reasonable anymore to say it's a provocation that your wife is in bed with another man? So it's got to be reasonable.
That's why I said when women were considered chattel, right? Exactly.
Or what if a woman is killing the husband in the bed with her best friend?
But what if a father is killing a sexual molester who's molesting his child? And I think that's where it becomes more important.
And this is the Socratic method we follow in law school, where it's always a what if, without a lot of answers. Hey guys, listen, that's why I love having Linda here. Let's go to the defense opening now. They got a tricky scenario to be in front of the jury, not to lose credibility on a case like this, especially after that prosecutor opening. We'll be right back. Okay, that's the defense opening statement in the Colley case. I got my Jersey girl with me, Linda. Getting to the point that we had raised just before that clip. He's trying to thread a needle here, and here's what it is. And I think that our lovers in that chat room who really love law will love these nuances, because in the end it comes to what the judge reads in the jury charge and the facts that could support it. And what he essentially is saying is that these medications, involuntary intoxication, allowed him not to form the intent. And what he's trying to get to with that, the attempt to intend, is attempt requires, under the law, an intent. It has to be a purposeful activity to be an attempt. So he's really trying to hit that. To me, it's a whole mitigation strategy at this point.
Right, well, yeah. You know, when I first heard about this case, and I think you and I commented on this case sometime back when it was first on, and it's great to reflect on these cases, I thought that it was going to be a really ridiculous defense, just to say, I'm taking Ambien and these other drugs, and therefore, you know, find me guilty of a lesser intent, of no intent. Manslaughter, passion, provocation, whatever. And then I thought, well, no. What the defense attorney is doing here is really setting the stage for mitigation. He says my client is guilty. He admitted that. So he knows that he's going to have a verdict against him. The question is, what is the verdict? And if the verdict is something less than the top count, will the judge agree to the fact that the medications cause some problems?
Now, just real quick, in states are different in how they do some of this law. Involuntary intoxication, for example, in many states, you cannot have consumed the product.
Right.
The fact that you may have had an adverse reaction is not involuntary intoxication.
You're absolutely right. But one of the things I looked up with Ambien is not really involuntary intoxication. It can make you, in some circumstances, not maniacal, but it can make you very tense. It can make you very angry. It can make you violent in some little small circumstances of the population that's taken it. So I think that's what they're trying to hang their hat on. Yeah. They don't have much, so they have to do something.
Yeah. Well, listen, folks, we're in the Colley case, and we do have many cases where people take things and then they have a negative reaction to it, but typically it's not a valid, straight, pure defense. But listen, at the Law&Crime Network, we're covering these things gavel to gavel. We have great guests like Linda. We're going to take a real quick break. We'll be back on the other end. Okay, welcome back. So that's Christine Keegan, and she's basically going through all the things, Linda, that were found inside the defendant's house. And as you can see, the pictures are pretty ominous of gun cases, guns, some pretty wild ammunition, carnage kind of stuff. So why do you think the prosecutor is being so methodical in going through her with each and every piece of evidence that was gathered there?
To show that he could pick out which gun he wanted, which ammunition he wanted, that he obviously had been collecting guns and ammunition. We don't know for what purpose, because as you know, in Florida, you can do that very easily. But everything was so meticulous. There was really nothing out of shape in his room but the ammunition and the guns, right?
Yeah, and you know, to get back to the point that we were talking about before, there's a difference between rage and passion provocation.
Right.
You can be enraged, and so long as you have an intent to go there and you have an opportunity to cool off and you don't, that all that stuff there shows well before he got to that crime scene, this guy was methodically taking stuff out, arming himself, which is all time that he could have cooled off. Thoughts?
That's right. And also it was rage not only against his wife, but against his wife's best friend, who he thought she was egging her on to be against him, right?
And the boyfriend.
And the boyfriend. So it wasn't just a pinpoint rage, which you see the passion provocation, like what we were talking about at the end. Some father comes along and sees that his daughter is being sexually assaulted and kills the sexual assaulter. Pinpoint, right? A pinpoint rage. But then this is against everybody.
Right, and you know what the psychologists will talk about, if a psychologist is called in a passion provocation case, and again, that greatly reduces the sentencing because it takes it out of murder and drops it usually to manslaughter,
right.
Is that the goal-directed behavior of the defendant belies or disproves the fact that they were just irrational in acting out.
And that's what we're talking about. The goal here wasn't just, you know, I'm going to kill my wife because she's done something wrong to me. I'm going to kill anyone who may be helping her because she's done something wrong to me. He had to think about that. And remember, he had to plan this, and he had to choose that morning, and he had a cooling off point, and he had a father to talk to intervening. This is a horrible crime.
Right, and the flashpoint too, guys, is that he had a court proceeding that the father said he was very agitated. This is motive. You may have rage, but you don't necessarily meet the definition of passion provocation. That's what the prosecutor's doing with this evidence. Hey, you're at the Law&Crime Network. We're doing the Colley case. We'll be back on the other end of the break. Stay tuned. Okay, this is the Colley case. There's two witnesses, the officer DeLuca and now Ms. Mano, who are talking about this phone conversation with respect to the father. Let's go back and listen to the final pieces of our conversation that were relevant to the prosecution, and I'll be back with Linda on the other end.
Speaking, the older gentleman that you were observing, did he identify the other person on the other end of the phone in any way? Like, could you tell who he was speaking to?
At one point, I heard him say the word son.
Okay, it was short and sweet. Linda Kenney Baden. I didn't even have a chance to put my fan down and turn it off. I went so fast.
You weren't sharing your fans, so I had no sympathy for you.
Came and it went so quickly. Okay, so what is the prosecution doing here, making this connection between, obviously, that the son is calling the father, DeLuca's talking about this, also DeLuca, as well as Ms. Mano. What's the relevance with respect to these conversations about something bad happening and don't do this, things of that nature?
Well, it could be two things. If this call were before she were killed, which I don't think it is, but if it were before, again, it inserts another act. He is talking to his dad, who obviously he respects, obviously he wants help from, and his dad is saying, please don't do this. Remember, this is his grandchildren too, right? If it's after, then it kind of shows that he can call his dad afterwards, and maybe he's trying to make some kind of cover. But again, he's talking about the incident. This is not just bang, bang, you're dead because I was upset for something I saw and I couldn't control my mind.
Yeah, and I think that it also goes directly to the heart of the defense's case that this stupor he may have been in or under the influence of any medication, he actually knows what he did was wrong, and he's actually calling and some conversations going on with respect to, yikes, something really bad happened.
And that's why I think they should be concentrating more on the Ambien, if indeed there is a section in the Ambien that says some people can get violent from it. Because if this is out of character, and that's what you have to go to, is this out of character? With every witness, You haven't seen this son before. Was today out of character? Was this out of character? You know, you need to set that up for the mitigation. You don't set that up. Goodbye, so long. Bring your toothbrush, pack it because you're going away for a long time.
Yeah, I guess you're right on that, and certainly can have an effect on the judge down the road. Perhaps maybe it can mitigate. I think it's more maybe you can get the one juror who's going to buy it, and you hang the jury maybe because it is really a bad case. I think it's a terrible involuntary intoxication case because if he even took it, he took it voluntarily, and the side effects are on you, and that's the law generally. Guys, you're at the Law and Crime Network. I'm here with Linda covering this Colley case, and we're going to come back and we're going to listen to more testimony in this fascinating case. If you got any questions, get inside that chat room. We'll be willing to answer them for you. We'll be right back. Okay, so Linda Kenney Baden. We have two witnesses that the prosecution puts on. One, his friend, the guy chewing the gum that wanted nothing to do with being on.
Who's looking like this.
Like, yeah, right. And so he certainly wasn't sympathetic to the prosecution and testifying against his friend. And the other one is Amy Mason, who's a girlfriend. And when you stitch these two pieces of witnesses and their evidence together, what you're finding out is, which I think is the essential crystalline points, is that he didn't like Lindy, who winds up dead, right? And she testifies that the wife was having an affair.
According to him.
According to him.
Right.
And he goes into a home where the boyfriend is, after having seen pictures of him with his shirt off and the sex toy thing and whatever, and tries to find out where he is. He's asking, where is he, where is he? And when he goes into that closet, I've said this from the beginning of this case, he shoots into the closet. Two people are in there. He bypasses one person and then goes and shoots Lindy. And then we know he goes in and shoots his wife, and we know that he was looking for the boyfriend. These two witnesses that are they're not pro-prosecution people, are really hammering an awesome motive, yes?
Absolutely, because here we have not just as a transfer type intent, he was shooting into the closet because he thought maybe the boyfriend was in there and accidentally killed Lindy. He targeted Lindy. You know, he went after her. He had a motive to kill. He had a dislike of her. Okay, so we know that. Now we know he believed, whether it's true or not, that his wife was having an affair. Now, the woman who's telling us that is the woman that this guy is now dating. Talk about moving on and having an intervening action should be separating your passion provocation. He is going out with her, right? So now we know that it's still in his mind that his wife has done him wrong. So we have two motives here. The direct motive to kill Lindy, and now the direct motive to kill his wife.
Right, and again, not only are those witnesses great, they're ones that you would imagine are going to be sympathetic to the defendant, and yet they're coming in and there's putting a stake for the prosecutor into the defendant's heart. You gotta love those kind of witnesses.
Sure, especially the first one, the guy sitting back there chewing the gum, kind of like, I don't really want to be here. The second woman was crying. She was absolutely crying. You saw the tears because remember, she's now dated a murderer. I mean, think about this. And she's given, and she didn't do anything because probably she didn't think anything of it at the time, you know, so about the motive.
Right. And do you think the prosecution is putting on a good case so far?
Oh, my God, yes.
I mean, they're really doing it methodically, are they not? I mean, they're giving the motive, the means, the opportunity, and each time they're hacking away at the defense.
And sometimes prosecutors don't put on their best case for the victims. This prosecutor is doing justice for these victims.
Yeah, you know, Linda, we talk about that all the time with the great trials that the Law and Crime Network always seems to poll. And we see a lot of the good and the bad and ugly in the prosecution world, and this is not one of them. This prosecutor is doing it methodically, by the book, not creating reversible error, and building a rock-solid case. Guys, we got to go to break, and we're going to come back with more analysis on this case on the other end. Stay tuned.
Equipment. Disgraced former Congressman Anthony Weiner, who is serving a 21-month prison sentence for sexting with a 15-year-old girl, will be released early for good behavior. Weiner, a once prominent New York Democratic congressman who resigned in 2011 following the release of sexually explicit text messages he exchanged with women other than his wife, is serving his sentence at the Federal Medical Center Devens in Massachusetts. Weiner is now scheduled for release on May 14, 2019. Those were today's top crime stories. I'm Anthony Velez for Law and Crime.
Linda, this Anthony Weiner story, we covered it a little bit earlier. We talked about the oddness of people like this, the compulsion to take themselves, and it's almost like a death wish. And with all the success and a beautiful wife and a beautiful career, just...
And a young child.
And a young child, which he took a picture of, which got him into a lot of trouble. Now, he's in the... I want to go back to this prison piece, because you know this better than anybody. You've represented some very high-profile clients, and he is a high-profile client. He's in the medical section. Talk to us about what that is and whether you think it was a good decision to let him out early because of good behavior.
Well, obviously, he's in the medical section because he's getting some type of treatment for his sexting, right? I mean, he's a sexaholic. He's got something wrong with him. I mean, we could be in different circumstances. He's a sex crimes person, right? That he'd have to register if it were different circumstances. So Carlos danger, I mean, you put yourself in danger, you put your kid in danger, you put your family in danger. I mean, I don't know what else to say about you except you're an idiot. Okay?
Carlos
All right,
Danger.
this Carlos Danger, that was his name. Now, should he get time off for good behavior? I'm a firm believer that you should, that it helps convicts, prison inmates, anyone who's going to be in for a period of time to do better in there, to follow the rules, to follow the regulations so that there's no riots, there's no corrections officers being hurt, because it's not that much time. If you take a week off for every year, it's not that much time.
I'm going to make a prediction that we're going to find out that he was in that medical facility because he was getting a little bit of a special treatment to keep him out of general population. And that's even in general population of sex offenders. Maybe he was doing some treatment, but a lot of times if somebody just can't be placed in the right environment, even among sex offenders, they kind of find ways to put them into the places where they can be a little bit more
Maybe
isolated.
a little of both, but I do think he needed treatment. Maybe a little of both, because let me face it, he's a target in prison.
Jersey girl, we can agree. The man needs treatment.
He
no
needs
doubt about
treatment.
that. Hey guys, listen, we're also covering the Colley case today. It gives me and Linda a great opportunity to give you some trial nuances. If you have an opportunity, get into that chat room. Linda's monitoring it. We're willing to answer any questions that you guys may have and always appreciate them coming forward. We've listened to a prosecutor putting a case together stitch by stitch, puzzle piece by puzzle piece, and the picture is becoming very, very clear, including calling the defendant's friend, I think it was his best friend, as well as his girlfriend at the time, Amy Mason, and she was on the witness stand and provided compelling testimony. It all goes to the prosecutor's gem in a case, even though you don't need it in a murder prosecution, but you love to have it, motive. Let's listen to Amy Mason's testimony. Well, so Linda, let's talk about, Amy Mason's testimony first.
Sorry for her.
I know. I mean, look, she literally had her mouth quivering and her body quivering, was fighting back tears throughout the entire thing. And let's talk about a little bit of the human dynamic. You have cases, and it tends to look at the defendant and the victim, but there are always so many more collateral consequences and people affected, and this is one of them.
Well, it's her because she dated him, and now she knows he was a killer. I mean, that's got to make her feel awful. She knows that he was getting texts. She's probably in her mind thinking, could I have seen this? Could I have done something about it? She's going to live with that. You also have the other you have family members. It's not just the victims. My husband, who's a forensic pathologist, likes to say that his job is easy because the people that are in pain aren't dead. The people that are left, the family, they're in pain forever when something bad happens. And you have the father of Colley, no matter what you think of Colley, you have the parents of the victim, you have nieces, nephews, girlfriends, you have everybody in the community who are victims of this, and it's never going to go away.
Right, and I know something's going to be going on. I'm not exactly sure if I heard exactly our producer what they're saying, but listen, the point is, I think that there's a lot of the collateral consequences, like we said, and one of these here. Okay, we're going to go to a clip, and we'll be back on the other end. Okay, so Linda, reading these text messages in court, what's attempted to be done here?
You see my reaction right now? I'm sleeping, okay? What's attempting to be done is that these are incredible text messages about what he's going to do, what he's saying, what the feelings are, right? And what are we doing? We're letting somebody read them who's fabulous at his job, no doubt about it. But you got to, theater, courtrooms are also theater, okay? And if you want to make those messages pop to be what Colley was thinking, you got to say them like what Colley was thinking.
Yeah, I mean, so you're talking about the substance of the messages is good, but the presentation was lacking.
Yeah.
Yeah, you know,
In a Jersey word, yes.
And let's talk about this. I mean, a lot of times you got to take your witnesses as you find them. I mean, there are some that are better at testifying and some that are very animated, get over well with the jury.
Put them up on the screen, Bob. Put the messages up on the screen. You know, I'm a big one for having, when I'm speaking, to have something behind me, if I can, if there's a way to do it, or something on the board. Not that it's going to take the jury's attention away, but you want something to pop. What do you wait for the whole time in a court situation to have the message that says I plan to kill her, or you know, I hate her, or I want to get my kids back, and you just can't let it die there, you know, no matter how good your case is.
Well, Linda, a lot of, I think, law students and people that are interested in training in the law watch the Law and Crime Network, and what I found happening in training hundreds and hundreds of prosecutors and trial lawyers in my career was that they would have a significant piece of evidence and not know how to blow it up and illustrate it beautifully to the jury. A perfect example of that is because they want to go through this checklist in their mind. Bing, 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 bing. Is when you have like a really good picture, and they have the witness identifying the picture and talking about, oh, to the left is the car, to the right is this, to the left is that, and the jury isn't seeing anything. So that ultimately, if they get that picture, they don't even know what was being testified to.
Or they have too many, right? I mean, I'm going to take a case that Law and Crime covered, which is Hernandez, and I had to deal with the issue of ballistics and tool mark matching. I put on 30 pictures. I used one important picture of the bullet comparison, just one, because one can make your point, you know, and you highlight things. So it's a technique. Now this is obviously a very good case.
Yeah, I've seen guys actually take the murder weapon, identify it, tag it, and stick it back into the box so it's outside the presence of the jury. But guys, listen, the Law and Crime Network is growing, it's expanding, it's getting greater and greater content. Our great Aaron Keller, my friend, has a new show. There you see him with his beautiful face, his matching tie and pocket square. I think he gets that from me a little bit. Let me just show you that. There you go. But anyway, Aaron's got a show, Daily Debrief, 5 to 5:30. It summarizes the biggest moments of the day. And you guys know that we are covering so much. And Aaron is perfect as a journalist, as a lawyer, to deliver that. I'm going to be watching that because I like to keep up on all those great things that are going on. So listen, we're going to take a quick break, and on the other end, we'll come back with more of the Colley case and Linda Baden. Okay, so we're watching clips of the defense opening in the Colley case, and Linda, we got a lot to chew here. Let's start with some basics. The opening statement is your first opportunity to speak to the jury. It's important to establish your credibility on only present data and information, especially as a prosecutor or defense lawyer for that matter, that you're able to deliver. Otherwise, your credibility goes right into the toilet.
Absolutely.
And the reason I say this is because he's opening this Ambien defense and the other medications, but never presented any evidence of it in the guilt phase of this case.
And, you know, this trial and the defense team, and I don't like to rag because obviously they had the hardest job, is only about trying to save Colley from the death penalty.
Right.
They know he is getting convicted. This is only about mitigation, and when you try a death case, you start actually with mitigation. You don't start with the facts when you start researching the client, meeting the client. So if you're going to have a defense that says the cocktail of drugs or one drug cause him to act out of what he normally would do, you better have witnesses to that. Now, that means witnesses about his daily life. That means the psychiatrists he went to, the doctors he went to, what effects the drugs have, and you have to thematic it all the way through the phase dealing with the penalty once he gets convicted. You can't just say, I'll bring it up, and then you close on it, and then once he's convicted, you say, okay, now we're going to talk about it again. The jury's not going to buy it. They're not waiting for it that long.
Right. So let's be clear about this. In the guilt phase, you're only allowed to introduce evidence that is relevant evidence and goes towards a defense. And this was involuntary intoxication, which, again, I don't think applies to this case. But nevertheless, that's it. Usually motions are held ahead of time, that legal arguments as to whether this evidence can come in or can't come in. I don't know if this was a tactical decision not to introduce it after he opened to it, or if a judge precluded it because it didn't meet the level of an intoxication defense. But nevertheless, that is just no bueno in front of a jury.
Then you do not open to it.
Then you don't open to it. And in fact, that's the reation why a lot of times tactically, a defense lawyer will talk more about the presumption of innocence and proof beyond a reasonable doubt and how difficult it is the prosecutor's burden rather than committing the facts.
And you can even tell a jury, and we're allowed to talk to you right now about what happened. If you convict our client, which we don't think you will, but if you do, we may have other things to speak about. So it's in the back of their mind, because remember, juries make up their mind generally 40% of the time at the opening statements.
Right. Okay, well, that's very good analysis, and we are going to go to a break, and on the other end, we're going to come back with some more of the fascinating tactics in this case. So far, prosecution's way ahead of the curve. We'll be right back. Okay, welcome back. That is Detective Colley, called by the defense after the prosecution had called him. Linda, we were debating a little bit about like what's going on here, because it could seemingly be bad for guilt, showing all of this, the guilt phase, showing all of this back and forth and this hostility and between these two people. So my first question is, what do you think the defense is doing here? I have a theory.
I can't wait to hear your theory, Bob, okay? Because what I saw there is that somebody who's talking to her and saying he's trying to get her to admit this affair, which she won't. First, he starts out by blaming her. You screwed up our family. You destroyed it by having an affair. She won't say she had an affair. She says she doesn't have an affair. And then they're talking about joint custody. He's going for joint custody. He says he's not mad. He says, I love you. But that's then. That's not the day he shot her. So I can't wait for your theory.
Here's my theory.
Okay.
My theory gets back to the point you made before. We all know that to defend a death penalty case, the old adage applies. Keep them alive another day, another hour, another minute. It's all about the penalty phase. The lawyer knows, the defense lawyer knows, I'm done, dead DOA. There's no way I'm getting out of this case on the guilt phase. I'm going to be headed to the penalty phase. So he's throwing in the Ambien, although I certainly would have wanted to call a witness about that. But he's basically saying, guys, listen, this is what's going on in the man's life. He's trying to make it work with Amanda. They're having a normal marital contempt that all people have, and it just started to escalate. He's not a monster. He's not a human being. They know he's going down in the guilt phase, trying to prepare themselves for the penalty phase to kind of take some zip off the fastball from the prosecutor. Thoughts?
Well, it could be, but then again, it goes to motive. It gives more of a motive.
But he knows he's dead. Motive is irrelevant in the penalty phase.
So then the question is, do you throw it all in? Which is, I think, what you're saying. You put it all in so that the jury can see what this man is from top to bottom during this period of his life. Can that work? Possibly. Is it bad? It certainly doesn't help them on the motive. Maybe it helps in the death penalty. I don't know, Bob.
Okay, listen, I got some other questions about this, and this is great having you because you know how to answer, but we are going to go to a break, and we're going to come back and do more of the Colley case, and I'll be speaking with Linda about it. Stay tuned. Okay, welcome back. We were just talking with Linda Kenney Baden about Detective David Colley's testimony in the Colley case. And, you know, the tactics of lawyers. You know, maybe he's doing this to humanize the guy. I'm not a monster. Priming that jury, knowing he's going to go down. So let's play to that penalty phase. Now, one other thing, Linda, interesting to me, is all of this being read word for word, which is out-of-court statements, the definition of hearsay itself, but it's being allowed to be admitted. You made an argument off the record, if you will, that the reason is that the prosecution had done it, but I question, why was the prosecutor allowed to do that?
Well, the prosecution was allowed to do it because there's admissions in there that go to motive, no doubt about it. So they're allowed to show that to the jury.
So now, just so it's clear, that admissions against interest are an exception to the hearsay rule.
Right, so that they are allowed to do that. Now, the defense could object to that because you can't just say, okay, I have my text here, Bob, and it says, I hate you, but then 3 lines down it says, I'm just kidding, I really love you, you know, I was just joshing with you. So that would be completeness. So obviously, if you're a defense in that situation, you want to have the whole thing read to show what the conversation looks like completely with these people, with the 2 people over a period of time. So it's because it may have a different bearing on even the motive ones that the prosecution read.
Right, so we have 2 important legal concepts that can make a huge difference in a case because evidence makes the difference. If you can't get that evidence in, say goodnight. It doesn't make a difference all of your fancy theories. You've got to be able to prove it. So we have hearsay, which is an out-of-court statement, an exception to hearsay, which is admission against interest because the courts deem it inherently reliable.
Right.
And then the doctrine of completeness, where the defense attorneys can say, whoa, wait a second, you took that out of context.
Right, or you didn't give it the complete context.
You didn't give it the, all right, okay, or we have a different context. This is why you gotta love having Linda and people like Linda on the show, and love this Law and Crime Network, because these are the nuances that good lawyers are going through in the introduction and counter-introduction of evidence. Let's listen to a little bit more of Detective Causey's testimony called by the defense. Don't forget. We'll be right back. Okay, welcome back. Now, that is Detective Causey. We've been talking about him extensively. That was under questioning, Linda, by the prosecutor. We had listened to him being questioned when he was recalled by the defense earlier today. Let's just talk about presentation and the use of demonstrative evidence between the two presentations to the defense and prosecution. What did you notice?
Well, we talked about it initially. Here, the prosecution had the witness reading, but also had a screen behind or to the side of the witness, highlighting the important text, especially the one where he calls his wife a bitch, right? That's kind of important. And so there's emphasis on that, as opposed to the defense, which was having him sit there, read these things, he was kind of hunched over and with no effect as to what was important.
Right, and we know as trial lawyers that if you can employ as many senses as possible when testimony is being delivered without being distracting, then you actually are amplifying in the regular human being's mind what it is that you're trying to present.
Right, that's absolutely correct. And you're also seeing the lead up to when he kills her and the lead up to when she has to go to court to prevent him from having contact with her, right? It's getting more heated, he's getting more heated. This is terrible stuff. For the defense. And
does this support the conclusion that you had given earlier when we were watching the reason the defense was able to get all that hearsay out, that this was the defense's way to say, whoa, wait a second, that's not all that they were communicating about?
That's right. They were also communicating about going for joint custody and for other things within their text, and that is the complete list. But it was mostly against Colley as opposed to helping him.
Definitely. Well, listen, guys, we are in the Colley case. I have Linda Kenney Baden with me. She's an amazing guest to have. This is an amazing trial because there's a lot going on here, especially with regard to lawyer presentation of the case. Team prosecution is doing a killer job in the case, a really good job. Awesome. We're going to take a break, and on the other end, we're going to break it down some more. Thank you. All right, welcome back. So, Linda, we're back to Weiner.
Carlos Danger.
Carlos Danger. Boy, risky guy, goes in. It was his federal prison, wasn't it?
Yes.
Now, they don't have the lowest classification, which is the camps. I think that you're actually put into a secure facility when you go to federal prison on a sex crime.
Yeah, but he's put into a medical facility, which means he needed treatment of some sort. They felt that he needed treatment. I don't think if he were being kept away from the general population, he'd be in the regular prison being kept away from the general population. He was in medical because they've decided that he has some kind of sex something or other.
Yeah, he's got a sex something or other for sure. Let me ask you a question. I've been throwing this to a lot of lawyers lately. High-profile guy, you've represented them, politicians, athletes, what have you. Do you think the sentencing should be modified at the time of sentencing a little bit, given the fact that these people have a very rough time in prison? Many of them are put in segregation. They can't be in general population. Is that a justifiable mitigating factor to maybe come off a little bit compared to the average person?
You know, I don't think so. Look at police officers who end up going in jail. They're few and far between, but they do. They have to be segregated for obvious reasons. It doesn't mean they should get time off because they're police officers who committed a crime, but they should be protected, because if you're giving them somebody a sentence of 15 years, you don't want to give them a death sentence where they get killed in prison by somebody. So I have no problem with keeping them in segregation. You
know, I'll tell you, as a prosecutor, I guess I would have been a good prosecutor for you to be a defense lawyer, because I would feel that when you're in 24 or 23-hour lockdown and in a place where your senses are being deprived, you don't have an opportunity to have connections and contacts, I did take that into consideration with regard to what plea offer I would give, because I would think that they were being treated harsher than the average person.
That's very interesting, Bob. You are a very compassionate person. Unfortunately, most prosecutors are not that way.
Well, you know, that's what can I say? Anyway, thank you.
At least the ones I've dealt with.
Yeah. So listen, on this Colley case, though, Linda, we've been breaking down a lot of what's going on here. What I felt fascinating, we looked at it before, we're going to look at it again, is that the prosecution was able to call two witnesses. One is one of his best friends and neighbor, Mike Pickens, to the witness stand. And you got to love it as a prosecutor when you can call somebody that's a friend of, family member of the defendant, and that testimony, despite the fact they may not want to give it, is putting the stake in the defendant's heart. That's a prosecutor's dream witness. Let's go to it. Okay, welcome back. Well, like we were saying, this witness is a friend and a neighbor of the defendant. They had numerous conversations about the victim, Amanda. He's basically saying that he's acting stupid. The defendant ransacked the house, busted up TVs, was telling him that he's being stupid because of the court orders. You can tell he doesn't want to testify favorably, but for the prosecution, but he's giving them great data, and nevertheless. Hey, guys, listen, I told you this before. Our friend Aaron Keller, who's a great journalist and a great lawyer, good friend. You see his pretty picture up there right now, and he's got the Daily Debrief with Aaron Keller that airs at 5 p.m., 5 to 5:30 every day, and it summarizes the best and brightest of the legal stories that are going on of the day at the Law and Crime Network. Aaron is a tremendous resource. I highly respect him for both being a great lawyer and journalist, and often when I'm doing legal matters or I'm commentating in other places, I go on and look at Aaron's articles. He's a precise writer. He's a precise journalist. He's got a lot of flair to him. 5 to 5:30, and I will be watching it myself. So please stay tuned for that. And we're going to right now go to a break. And on the other end of the break, we're going to come back with more Law and Crime. It's been a heck of a day here going over this Colley case, so stay tuned. We'll be back. Welcome back. Okay, that's a defense witness, Rhonda Colley Boatwright, the sister of the defendant, Linda Kenney Baden. I'm confused as to what the... First of all, as a prosecutor, let me take it from the prosecutor's point of view. I'm not even sure what this testimony is doing to hurt my unbelievably solid case. And when you have a witness like this, the only thing that I can do by crossing her about where you're right then, right then, she's giving a credible explanation, whether you believe it or not. I was confused. My brother was just charged with murder. I don't know if maybe I admitted something, maybe I didn't. I don't know. Why get into that cage when your case has gone in so well and battle a witness like this?
You don't need it. You really don't need it, because if the defense put her on, let's say the defense put her on the stand, because we were totally confused about her, right? To try to show that he has a family and the family's nice. I mean, what is she going to do? Admit to things? Say her brother's a terrible person? No, probably not. You know. And so,
I can tell you,
just you keep throwing in that sword. You don't need to do that.
Yeah, and I can tell you in a number of occasions that I've had as a prosecutor on murder cases where I've been cross-examining family members, maybe providing an alibi or something else, where ultimately I was very gentle with them. I tried to even, remember once in an alibi case, I just did it this way. Hey, you really love your grandson and you don't want to see anything bad happen to him. Yeah, I said, you know what? I have no further questions. I actually touched her on the hand and I walked away. And you know what? Other people could have gone and hammered her. How could you remember 3 years ago? And blah, 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 blah. I can do that in summation. I don't need to do that through the witness.
That's right. And when you're crossing family members, there used to be an old saying, a really old saying, that when people were into Westerns in the 60s, when those people were talking to us as young lawyers, even Jesse James had a mother. So now you'd want to say something, you take the worst person in the world, you want to say, even he had a mother, even she had a mother. Just leave it alone.
Right. Well, listen, this is unbelievable stuff. I agree that this was probably an inconsequential witness in my mind, other than humanizing the defendant. But we're going to go to a break, and on the other end, we'll come back with more Law, Crime, and the Colley case, and, of course, the great Linda Kenney Baden. Okay, welcome back. This is one of my favorite parts of the day, because if it is, and let's see, 2:34, then you know it's time for Flip the Script. Now, Linda Kenney Baden has absolutely no idea, I believe, of what it is that I'm even talking about. And I played this little game with one of our guests, our great guest the other day. So, Linda, you're going to play with me. And the name of the game, Flip the Script, is now that since you're the guest today and I'm hosting, I'm going to flip this script and you're going to host and I'm going to be the guest. And I'm going to give you an opportunity to ask me a question that I can answer so I can sit back, relax, and wait for that question to come and answer it.
Okay, on anything?
Go ahead, on anything. Why not?
So let's talk about the guy who took his ankle bracelet off, Bob.
Excellent. Let's talk about that guy.
Let's talk about that guy. Stupid or smart?
Both. But both? Because these guys, come on, we know this. If they put their minds to something legitimate, they could have been a huge success. And that's the smart piece. The smart piece is knowing how to do it. The smart piece is knowing how not to break the circuit so that the thing won't go off. The stupid piece is, and let's face it, if there wasn't for stupidity, prosecutors, judges, defense lawyers, court officers, the Law and Crime Network would not have income. We wouldn't be able able to operate without these. We should be thankful to them, to guys like this. But here's the point. The stupid piece is you don't put it on social media, you moron. Otherwise, you're going to have to hire a guy like me or Linda.
Well, let me tell you, in our first book, our first novel, my husband and I did, called Remain Silent, we had somebody take off their ankle bracelet, but we didn't tell anybody how to do it.
Yeah,
that's the smart piece.
My last piece on this, the producers are so good to let me flip the script, but I got to tell you, if I didn't say it before, I'm not sure. I was just talking about the other day, trying an armed robbery shooting case as a young baby prosecutor, bad identification, really hard case for me to prove. The person could only identify the guy as wearing an 8-ball jacket with a rip in the front and describe the jacket really well. Well, you can't make it up. It's just like this guy with the ankle bracelet thing. In the middle of the trial, the defendant comes in with an 8-ball jacket with a rip in the front of it. And I caused pandemonium in the courtroom when I told the sheriff's officer, seize that jacket. The defense attorney was, it's like a tug of war going on in the courtroom.
But these are the crimes that are kind of fun, if there are fun crimes, as opposed to what we're seeing with Colley, which are terrible crimes.
You're right.
You know, there's no in between.
You're right. You can't make, but you know what? There's a lot of humor in the law, too, and that's why I like to do a little flip the script.
There is a humor. You know why? In the Supreme Court yesterday, Justice Kagan did this. She reached over
hashtag me too.
She pinched
I know.
Gorish.
I know.
Pinched Gorish.
Yeah, and apparently he didn't know that was coming.
I've been dying to do that.
And was freaking. I know you've been waiting to pinch me all day. Hey, listen, this is my Jersey girl, Linda Kenney Baden, and we can have fun with this stuff because there is a lot of humor in the law, like there's in everything in life. You can't be too serious about stuff, especially when you're dealing with a case like the Colley case. And I think that we wind up having a henchman's macabre sense of humor because we deal with the horror of a case like Colley. And right now, we're going to go into ultimately what's important, and that's this case and winning the case and the prosecutor doing their closing statement. Here's where they get to tie all the evidence together, and they started with their opening. They put some really good witnesses on, Linda, and now they're going to try to tie it together. Let's go to the closing. Okay, so there we go with the prosecutor's closing. Linda, look, we can beat this case up 9-1 to Sunday. The case went in really good for the prosecution. Of course, ultimately, the defense goal is to spare his life.
Right.
Now, the use of demonstrative evidence. We've kind of been playing around with this a little bit. I am very uncomfortable in front of a jury with the PowerPoint presentations. I did do it in a murder case not too long ago. But I felt tied down. I feel more comfortable when I'm emoting and using very limited demonstrative evidence. One, because I think it just kind of throws me. I kind of intuit when I speak. I don't have like a set pattern down. Okay. I like some really important things to put up there, but once I did it with a lot of stuff because my partner wanted to do it that way, and I felt like I was in a cage.
Well, I mean, two schools of thought on that. There's some recent studies that have come out that jurors, when they see too much PowerPoint, they don't pay attention. They will pay attention to you if you speak to them without without PowerPoint. When I tend to use it, I used it. Most I ever used it was in the Spectre 1 trial when I closed, because we had 2 days of closing, and I had my own things that I was going to say, but I had generic PowerPoints behind me that the person who was running it wasn't me, knew when to flip to the next PowerPoint, because it would emphasize what I had just said from my closing that I was giving, but I wasn't necessarily tied to it. So that's how I like to use it in certain circumstances. But the new way is that people will listen to you more without anything behind you. You
know, it's funny you should say that, because what I tend to do is to trying to work out this nuance with this new technology that we have, is to do my summation straight out. And then at the end, I say, so let me recap this for you. And then I start showing the demonstrative pictures along with it. So it gives me an opportunity to get 2 bites at the apple. That's
the way. You're so smart.
Well, that's whatever. But listen, guys, it's been great with being here with Linda. She's an awesome guest to have. You, we are going to go to a quick break, and on the other end of that, we're going to come back with more law. Are you leaving us at this? I got to sign you out? Yeah. Well, I'm going to say goodbye to my Jersey girl, Linda Kenney Baden. Thank you, Linda, so much. And we're going to go to a break, and we'll be back on the other end, and hopefully me and Linda will be back together soon.